Welcome class. Today we are reading Indian Evidence Act 1872. So let's start. Part 1, Relevancy of Facts. Chapter 1, Preliminary. Section 1, Short Title, Extent and Commencement. That means how much or in which territory the Indian Evidence Act is in effect. This act may be called the Indian Evidence Act and it extends to the whole of India. So, the Indian Evidence Act applies to the whole territory of India, and the words except the state of Jammu and Kashmir were omitted by the Act of 34 of 2019. It applies to all judicial proceeding in or before any court. So, it applies to only judicial proceeding. Now, what is judicial proceeding? Every proceeding in which evidence is taken on oath, and the most important thing is the object of a proceeding in which the main aim of the proceeding is to establish the jural relationship between the parties. That is called judicial proceedings. So, the Evidence Act applies only to judicial proceedings. Next, it also applies to court martial other than court martial convened under the Army Act, the Naval Discipline Act, the Indian Navy Discipline Act 1934 and the Air Forces Act. So, the Indian Evidence Act also applies to court martials except these specific laws or special laws, because the Indian Evidence Act is a general law and special statutes always prevail over the general statute. Now, this act does not apply to affidavits presented to any court or officer. So, the Indian Evidence Act does not apply to what? Affidavits. Affidavits, I think you all know what an affidavit is. So, the Indian Evidence Act does not apply to affidavits, nor to proceedings before an arbitrator. So, the Indian Evidence Act does not apply to a proceeding before an arbitrator, because before the arbitrator proceedings are not on oath but only on the basis of affidavits and the parties' submission. There is no, like general civil or criminal proceeding or investigation or evidence taking matter. So, in arbitral proceedings, the main aim of the proceeding is to come to a peaceful solution by compromise, or arbitration is an alternative dispute resolution mechanism. So, when somebody goes before an arbitrator, the strict rule of evidence is not required to be followed in that proceeding. The main aim of the proceeding is to what? The main aim of the arbitral proceeding is to buy peace between the parties, because arbitral proceedings are generally take place related to business concern, industrial disputes and partnerships, economic concerns. These are arbitral proceedings, or clause of arbitration are provided within the contract in those matters. So, the arbitral proceedings, in an arbitral proceeding, one need not to follow the strict rules of evidence proving facts. Now, this act shall came into force on the first day of September 1872. So, when it will came into force? It will came into force on the first day of September 1872. Repeal of enactments. Section 2 says this section was repealed by the Repealing Act 1938. So, Section 2 was repealed by the Repealing Act 1938. Now, the important section of Chapter 1 preliminary chapter, that is interpretation clause. Section 3 says interpretation clause. In our previous videos, we have on several occasions discussed the difference or main difference between an interpretation clause and a definition clause. An interpretation clause is liberal clause where the definition given in the statute is also open to further explanation, further interpretation. But in a definition clause, the four corners of the defined thing or defined object is closed, and one cannot go through the process of interpretation beyond what is defined in the definition clause. So this is the main difference between the interpretation clause and the definition clause. Now come to section 3 of the Indian Evidence Act. In this act, the following words and expressions are used in the following senses. That is, unless a contrary intention appears from the context. So the following expression, that like quote, fact, these expressions are generally used in the senses given in the Evidence Act, unless a contrary intention appears from the context. But if there is a situation, or from the context of a situation it appears that the quote or fact in those situations meant something else, it will be taken into consideration. It is not like a definition clause, so it is liberal in taking several kinds of or several angles of the interpretation, I mean perspectives of interpretation. So first clause is court. What does the court means under the Indian Evidence Act? Generally, under the Indian Evidence Act, court includes all judges, magistrates and all persons except arbitrators, because Evidence Act does not apply to arbitration proceedings, except arbitrators legally authorized to take evidence. So all judges, magistrates and all persons legally authorized to take evidence, but except arbitrators. Now second clause is fact. What is a fact? Fact means and includes, number one, anything, state of thing or relation of things capable of being perceived by the senses. So first clause, first sentence of a fact means and includes says, that is anything, state of thing, relation of thing capable of being perceived by senses, that means which is tangible in nature. And second point says any mental condition of which any person is conscious, that is intangible things or situations can also be a fact. That's why it said any mental conditions. Suppose anything which is, according to the science, we know there is air, there is several kinds of gases, but we cannot touch it, test it. So, we may test it, but we cannot touch it. So any mental condition, there is gaseous substance in the environment, this is a mental knowledge, or we can perceive it through consciousness or senses. That's why any mental condition of which any person is conscious is also a fact. So facts means and includes, number one, anything or state of things or relation of things capable of being perceived by senses, that is our five senses, and number two, any mental condition of which any person is conscious. Now for example, that there are certain objects arranged in a certain order in a certain place is a fact. That a man heard or saw something, it is also a fact. That a man said certain words, it is also a fact. That a man has certain reputation, it is also a fact. That a man holds a certain opinion about a fact, about something, this holding of opinion is a fact. Now in these all this illustration, please understand the logic behind these illustrations. That if we take for example that a man holds certain opinion is a fact. Now if you hold any opinion about a pen, that the pen that may be a pen coated with gold and that have been stolen. So when the proceedings of going on of theft, in that proceeding you giving as, I mean, you have been called as a witness and giving evidence as that you have seen that pen on the table at 12 a.m. Now, the pen at the point of time was at the table or not, this is not a fact. But you hold an opinion about the pen at the point of time that it was on the table at 12 a.m. This opinion is a fact. Whether the pen was at that time on that table or not, this is not a fact. That have to be proved through another or other evidences. But your evidence, you as a witness, or your statements is a fact. Just your opinion is a fact. A man has a certain intention is also a fact. A man acts in good faith or acts fraudulently or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation are also facts. So these are facts. Now, what is relevant? Relevant simply means appropriate to the time, period, or circumstances. Now, generally, what do we mean by relevant? Relevant means that the point of discussion, or the point on which we are discussing about a fact, and the entire surrounding circumstances of that fact is relevant factor. So relevant simply means appropriate to the time, period, and circumstances. Now one fact is said to be relevant to another when? Now one fact is said to be relevant to another when the one is connected with the other in any of the following ways referred to in the provision of this act relating to the relevancy of facts. That is chapter 2 section 5 to 55, which deals with the relevancy of facts. So if whether any fact is relevant or not, it have to be tested through the process given in chapter 2, that is 5 to 55, through the process of all these sections. Now each of the section is not, I mean all of the section is not applicable to a particular situation of fact, but some of them may apply, and through which we have to test whether a particular fact is relevant or not. Now fact in issue. Now what is fact in issue? Simply understand that fact in issue means the ultimate point of difference. That means the point at which one party, or I mean the point about which one party is affirming, the other party is denying. That point is the ultimate point in dispute, and that is the fact in issue which have to be decided by the honorable court. Now coming to the clause fact in issue, what the Evidence Act says? Evidence Act says fact in issue, simply speaking, whether plaintiff mentions, when plaintiff mentions a fact and the other party denies it, that gives rise to a fact in issue. According to the Act, fact in issue means and includes any fact from which either by itself, that means the fact itself, or in connection with other facts, or the fact in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability. So whether that fact itself or in connection with other facts proves or disproves the what? The existence or non-existence or nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. So whether whether that right existed or not, what is the nature of that right, what is the extent of that right, or whether that liability existed or not, whether that disability existed or not, or what is the nature or extent of that or those liability or disability asserted or denied in any suit or proceeding by the parties necessarily follows. This is a fact in issue, because that right, liability or disability is asserted or denied through the facts by the adverse parties. Now explanation. Whenever under the provision of the law for the time being in force relating to civil procedure, any court records an issue of fact. Now this is not fact in issue. Fact in issue is the heading of the clause. Now explanation says issue of fact. Whenever under the provision of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in answer to such issue is a fact in issue. So, when in a civil proceeding, any court records an issue of fact, that means court records a issue about which the result or the issue recorded by the court, and on which a proceeding or after the adverse party submissions a point will be arrived at, and that point will be a fact in issue. So any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact in issue. Illustration. Ramesh is caused for the murder of Ramesh is accused for the murder of Jignesh. So at the trial the following facts may be in issue. What are the facts? The scenario is Ramesh is accused for the murder of Jignesh. Now at the trial the following facts may be in issue. What? That Ramesh caused Jignesh's death. This is a fact in issue which have to be decided either in positive or negative. That means whether Ramesh caused Jignesh's death or not. But the question is, or the fact in issue is, or the allegation is, Ramesh caused Jignesh's death. That Ramesh had the intention to cause Jignesh's death. Whether Ramesh had the intention or not, that will be decided in the proceeding. That at the time of murder, Ramesh was out of town. Whether Ramesh was out of town or not, that will be decided in the proceeding. These are the fact in issue. All the above are facts related in the case. That's why fact in issue is that fact without deciding or without arriving at a point on which the case cannot be decided. Now next clause is document. Now what does the Evidence Act says about the document? Document means any matter expressed or described upon any substance by means of letters, figures or marks, or by more than one of those means. So documents does not only mean that paper. Evidence Act includes all things and says document means any matter expressed or described upon any substance by means of letters, figures, marks, or by more than one of those means, intended to be used or which may be used for the purpose of recording a matter. Now simply understand that a writing is a document. Map, plans, sketch, prints, photographs, etc. are also documents. Now Evidence Act gives some illustration, that is, a writing is a document, words printed, lithographed, photographed are documents, a map or plan is a document, and inscription on a metal plate is also a document. An inscription on a stone is also a document. A caricature is also a document. Now this metal plate, stone, caricature, what is the reason these are recognized as document? Because the definition says any matter expressed or described upon any substance by means of letters, figures, marks, or by more than one of those means, intended to be used or which may be used for the purpose of recording that matter. So anywhere, if any matter is recorded, it may be on a piece of cloth. If the matter is recorded on a piece of cloth, then that can be also regarded as document or documentary evidence. Now, the Evidence Act says, what does the evidence mean? Evidence simply means proof, confirmation, in Hindi sabut. So एविडेंस एक्ट मीन्स प्रूफ और कन्फर्मेशन, और हिंदी में इसको हम क्या बोलते हैं, सबूत, और बांग्लाয় की बोली, प्रमाण. एविडेंस एक्ट कैन बी ओरल evidence or documentary evidence. So evidence, now we can divide evidence into two categories. What are the categories? Now number one is oral evidence, number two is documentary evidence. Now what is oral evidence? Oral evidence means and includes all statements which the court permits or requires to be made orally before it by witnesses. So all statements which the court permits or requires to be made orally before it by witnesses in relation to matters of facts under inquiry. And documentary evidence means all document including electronic records produced for the inspection by the court. So evidence can be divided into two parts, that is oral evidence and documentary evidence. Oral evidence is all those statements which the court permits or requires to be made orally before it by witnesses in relation to matter of fact under inquiry. And documentary evidence means and includes all documents including electronic records produced before the for the inspection before the or by the for inspection by the court. I'm sorry, that is produced for the inspection by the court. That is documentary evidence. Now the clause says proved. What does the word proved means in the Evidence Act? Now, a fact is said to be proved when, after considering the matter before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it exists. At that point of time, it can be said that the matter is proved. Now, court believes the facts to exist or considers its existence probable, most likely, expected, that a normal man under the circumstances of a particular case assumes it to exist. Now, disproved. Disproved means a fact is said to be disproved when, after considering the matter before it, the court either believes that it exists, either believe it does not exist, or consider non-existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it does not exist. So, proved means a fact is said to be proved when, after considering the matter before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it exists. Now, disproved, it is vice versa of proved. It says a fact is said to be disproved when, after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of a particular case, to act upon the supposition that it does not exist. This is the meaning given by the Indian Evidence Act to the words proved, disproved, and another one is not proved. What does not proved means? Not proved generally means when a fact is neither proved according to the meaning assigned it in the Indian Evidence Act under the clause proved, and not proved or disproved. And disproved is when we can say that it is not disproved. A fact is said to be disproved according to the Indian Evidence Act, after considering the matters before it, there is the clause. According to the clause, the meaning will be assigned to it. So when a fact is neither proved nor disproved, then it is said to be not proved. So there is a difference. Always remember that there is a difference between not proved and disproved. If it is disproved, or if any fact is disproved, that means a proceeding has taken place regarding that fact, and after considering the matter before it, court has derived at a conclusion that the matter is disproved. But in case of not proved, the matter is neither proved nor disproved. That means any proceeding regarding that point or fact has not taken place. Lastly, India means the territory of India. Now the last section of the chapter 1 preliminary chapter is section 4. Here are certain expressions, that is certifying authority, digital signature. You can read it by I mean if you want to read it, you can pause the screen. Now we are discussing the important aspects of the Evidence Act, so we may skip a little bit. I think it is permissible. And now we come the important section of preliminary chapter 1, that is section 4, may presume. अब यहाँ से हम थोड़े थोड़े से हिंदी में आपको समझाने की कोशिश करेंगे कि क्या बताया गया है. तो चलिए शुरू करते हैं. मे प्रिज्यूम, whenever it is provided by this act that court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. तो यहाँ पर क्या बताया गया कि whenever it is provided by this act that court may presume a fact, that means कोर्ट को पावर दिया गया है, डिस्क्रिशनरी पावर, कि कोर्ट अपना एक ओपिनियन ले सकते हैं और कुछ प्रिज्यूम कर सकते हैं. तो जब ये डिस्क्रिशनरी पावर कोर्ट को दिया जाता है, क्योंकि सेक्शन का हेडिंग क्या कहता है, मे प्रिज्यूम, मतलब कोर्ट चाहे तो प्रिज्यूम कर भी सकते हैं, नहीं भी कर सकते हैं. तो इसीलिए इट में आइदर रिगार्ड सच फैक्ट एज प्रूव्ड. अब ये जो प्रिजम्पशन है, ये किसके और किस चीज़ के बारे में है? ये वेदर एनी फैक्ट इज प्रूव्ड और नॉट प्रूव्ड और डिसप्रूव्ड, इस चीज़ के बारे में प्रिजम्पशन क्या कोर्ट कब ले सकते हैं, यही बताया गया है. और इसीलिए सेक्शन 3 के बाद सेक्शन 4 में ये चीज़ डिस्कस किया गया है. तो ऑलवेज रिमेंबर दैट ये जो प्रिजम्पशन है, ये किस चीज़ के बारे में है? किसी चीज़ की प्रूव्ड, नॉट प्रूव्ड और डिसप्रूव्ड के बारे में है. सो व्हेनेवर इट इज़ प्रोवाइडेड बाय दिस एक्ट दैट एनी कोर्ट में प्रिज्यूम ए फैक्ट, इट में आइदर रिगार्ड सच फैक्ट एज प्रूव्ड अनलेस एंड अनटिल इट इज़ डिसप्रूव्ड, और मे कॉल फॉर प्रूफ ऑफ इट. मतलब कि वो चाहे तो इसका प्रूफ भी मांग सकते हैं, प्रिज्यूम ना करके इसकी प्रूफ मांग सकते हैं. अब देखिए क्या बताता है कि अब ये गया मे प्रिज्यूम, मतलब कि जहाँ पर कहा गया है कि कोर्ट मे प्रिज्यूम, किसी सेक्शन में, किसी प्रोविजन में, किसी भी जगह पर अगर ये स्टैट्यूट का ये इंटेंशन है कि कोर्ट मे प्रिज्यूम, तो कोर्ट चाहे तो उसको एज प्रूव्ड ले सकते हैं, और उसको प्रूव करने के लिए जो पार्टी उसको असर्ट कर रहा है उसको कह सकता है कि आप इसे प्रूव कीजिए. अब देखिए शैल प्रिज्यूम. अब मे प्रिज्यूम तो हमने समझ लिया कि कोर्ट की डिस्क्रिशनरी पावर वहाँ पर है, लेकिन जब शैल प्रिज्यूम आता है तो ये जो शैल है ये एक मैंडेटरी वर्ड है. सो व्हेनेवर इट इज़ डायरेक्टेड बाय दिस एक्ट दैट द कोर्ट शैल प्रिज्यूम ए फैक्ट, it shall regard such fact as proved unless and until disproved. मतलब जब किसी भी प्रोविजन में या एक्ट में इंटेंशन ऑफ द लेजिस्लेचर हम लोग ये अब देखिए इंटेंशन ऑफ द लेजिस्लेचर हम लोग कहाँ से समझेंगे? इंटेंशन ऑफ द लेजिस्लेचर हमको फ्रॉम द वर्ड्स गिवन इन द स्टैट्यूट, वहीं से पता चलेगा. अब ये जो स्टैट्यूट अगर लिखते हैं कि द कोर्ट शैल प्रिज्यूम, मतलब यहाँ पर इंटेंशन ऑफ द लेजिस्लेचर क्या है कि कोर्ट की कोई डिस्क्रिशनरी पावर यहाँ पर नहीं दी गई। यहाँ पर सिर्फ बताया गया है कि कोर्ट को ये प्रिज्यूम करना पड़ेगा। तो तब कोर्ट क्या करेंगे, तब इट शैल रिगार्ड सच फैक्ट एज प्रूव्ड अनलेस एंड अनटिल डिसप्रूव्ड। अब देखिए ये जो मे प्रिज्यूम एंड शैल प्रिज्यूम हम लोगों ने डिस्कस किया अब तक, कंक्लूसिव प्रूफ में हम आ रहे हैं, लेकिन अब छोटी छोटी सी चीज़ें बारीकी से समझ लीजिए तो ज़िंदगी भर याद रहेंगे। तो क्या है, मे प्रिज्यूम में तो डिस्क्रिशनरी पावर है, यहाँ पे तो कोर्ट प्रूफ मांग ही सकते हैं प्रिज्यूम ना करके। अब देखिए यहाँ पर मे प्रिज्यूम में भी ये क्लॉज दिया गया है कि अनलेस एंड अनटिल इट इज़ डिसप्रूव्ड, मतलब वो जो कोर्ट प्रिज्यूम करेगा कि इट इज़ प्रूव्ड, तब भी अगर अदर पार्टी इसको डिसप्रूव कर देता है तो फिर कोर्ट का प्रिजम्पशन सर्वाइव नहीं करेगा। मतलब कि कोर्ट किसी फैक्ट को अगर एज प्रूव्ड ले भी लेते हैं, तब भी अदर पार्टी के पास उसको डिसप्रूव करने का ऑप्शन हर वक्त ओपन रहता है। मतलब उनके पास ये ऑप्शन रहता है कि उस फैक्ट को डिसप्रूव करने का, नहीं तो फिर इनजस्टिस हो जाएगा। इसको समझिए थोड़ा सा। और इसमें क्या कहा गया, मे प्रिज्यूम में कोर्ट इसको प्रिज्यूम ना करके प्रूफ, ऐसे भी प्रूफ मांग सकते हैं, लेकिन जब शैल प्रिज्यूम आएगा कोर्ट को प्रिज्यूम करना ही पड़ेगा। कोर्ट प्रिज्यूम अकॉर्डिंग टू द इंटेंशन ऑफ द लेजिस्लेचर द ऑनरेबल कोर्ट विल प्रिज्यूम दैट द फैक्ट इज प्रूव्ड, बट देयर इज ऑल्सो एन अपॉर्चुनिटी गिवन टू द ओपोनेंट पार्टी अनलेस एंड अनटिल इट इज़ डिसप्रूव्ड। दैट मीन्स विपक्ष के पास उस फैक्ट को डिसप्रूव करने का मौका तब भी रहेगा, ये मौका उनसे कभी छीना नहीं जाएगा। मतलब कि वो अगर इसको डिसप्रूव करने में फेल कर जाते हैं तब तो प्रिजम्पशन सर्वाइव कर गया, और अगर वो सक्सेसफुल हो जाता है तो फिर प्रिजम्पशन, इंटेंशन ऑफ द लेजिस्लेचर जो भी हो, लेकिन कोर्ट की वो प्रिजम्पशन सर्वाइव नहीं करेगी। अब देखिए कॉन्क्लूसिव प्रूफ। अब कॉन्क्लूसिव प्रूफ के बारे में बताया गया है कि व्हेन वन फैक्ट इज डिक्लेयर्ड बाय दिस एक्ट टू बी कॉन्क्लूसिव प्रूफ ऑफ अनदर, मतलब एविडेंस एक्ट में ही बताया गया है कि एक फैक्ट है, वो फैक्ट, मतलब ले लीजिए कि अब इलस्ट्रेशन में जब हम आएंगे तो फेमस इलस्ट्रेशन है, पता चल ही जाएगा कि when one fact is declared by this act to be conclusive proof of another, the court shall on proof of the one fact regard the other as proved। तो जब किसी चीज़ को किसी दूसरे चीज़ के होने का या ना होने का कॉन्क्लूसिव प्रूफ मान लिया जाता है, तब ये जो पहला चीज़ है ये अगर प्रूव्ड हो जाए तो दूसरा चीज़ ऑलरेडी प्रूव्ड हो गया है ये पकड़ लिया जाएगा। यही बताता है कॉन्क्लूसिव प्रूफ, क्या कि व्हेन वन फैक्ट इज डिक्लेयर्ड बाय दिस एक्ट टू बी कॉन्क्लूसिव प्रूफ ऑफ अनदर, मतलब अब ये वन फैक्ट और अनदर फैक्ट जो है, इसको अगर हम फर्स्ट फैक्ट एंड सेकेंड फैक्ट करके पढ़े तो देखिएगा कि जब ये एक्ट बताता है डिक्लेयर्ड बाय दिस एक्ट टू बी कॉन्क्लूसिव प्रूफ ऑफ अनदर, मतलब सेकेंड फैक्ट, फर्स्ट फैक्ट जो है वो सेकेंड फैक्ट के होने के या ना होने के कॉन्क्लूसिव प्रूफ है। तो ऑन प्रूफ ऑफ दी वन फैक्ट, मतलब अब देखिए ये जो फर्स्ट फैक्ट है एंड सेकेंड फैक्ट है, ये वाइस वर्सा भी हो सकता है। मतलब अगर सेकेंड फैक्ट प्रूफ हो गया है तो फर्स्ट फैक्ट प्रूफ हो गया है ये पकड़ लिया जाएगा और प्रिज्यूम किया जाएगा, ऐसा अगर कहा गया है। और अगर वाइस वर्सा हो तो अगर फर्स्ट फैक्ट प्रूफ हो गया है तो सेकेंड फैक्ट भी प्रूव्ड हो गया है, ये पकड़ लिया जाएगा, प्रिज्यूम किया जाएगा, पूरे प्रोसीडिंग को फिर से रन नहीं कराना पड़ेगा। ऐसा अगर कहीं पर बताया गया है कि इंटेंशन ऑफ द लेजिस्लेचर आर सच इज सच, तो क्या होगा, ऑन प्रूफ ऑफ वन फैक्ट, एक फैक्ट के प्रूव होने पर द कोर्ट शैल रिगार्ड द अदर एज प्रूव्ड, मतलब दूसरा भी प्रूव्ड हो गया है ये कोर्ट प्रिज्यूम कर लेगा। और क्या है, एंड शैल नॉट अलाउ एविडेंस टू बी गिवन फॉर द पर्पस ऑफ डिसप्रूविंग इट। अब ये देखिए, ये जो पहले जो मे प्रिज्यूम में तो डिस्क्रिशनरी पावर हेडिंग में ही है, कोर्ट मे प्रिज्यूम। अब ये जो शैल प्रिज्यूम हमने पढ़े, ये शैल प्रिज्यूम में भी डिस्क्रिशनरी पावर कोर्ट को नहीं दिए गए, लेकिन ओपोनेंट के पास ऑप्शन है उसको डिस्प्रूव करने का। लेकिन जब कंक्लूसिव प्रूफ की बारी आती है तब क्या होता है, अगर कोई भी एक फैक्ट प्रूव हो जाता है और दूसरे को कंक्लूसिव ऑफ अनदर अगर ये एविडेंस एक्ट डिक्लेयर करता है, तब देखिए द कोर्ट शैल नॉट अलाउ एविडेंस टू बी गिवन फॉर द पर्पस ऑफ डिस्प्रूविंग इट। तब दूसरे पक्ष के पास वो जो अपॉर्चुनिटी शैल प्रिज्यूम एंड मे प्रिज्यूम में था उसको डिस्प्रूव करने का, वो अपॉर्चुनिटी और नहीं रहेगी और नहीं दी जाएगी। अब देखिए इसके जो इलास्ट्रेशन तो यहाँ पर हमने जो जिन्होंने ड्राफ्ट किया है उन्होंने यहाँ पर नहीं दिया। आप एक एग्जाम्पल ले लीजिए, समझ लीजिए कि 112 ऑफ द एविडेंस एक्ट, दैट इज लेजिटिमेसी ऑफ द चाइल्ड। ये एक बहुत ही फेमस एग्जाम्पल है। अब देखिए, ड्यूरिंग वैलिड वेडलॉक, आई मीन ड्यूरिंग द वेडलॉक and within 281 days of dissolution of marriage, if a child takes birth, then who will be the father of the child? That is the divorced husband. अब देखिए इसको आप लोग जो पहली बार पढ़ रहे हैं उनके लिए थोड़ा सा क्लियर करके हम बताते हैं। अब देखिए, समझ लीजिए ए और बी के बीच में शादी हुआ है और 2 साल बाद डिवोर्स हो जाता है। अब डिवोर्स होने के 15 दिन बाद ये जो वाइफ है इनकी प्रेगनेंसी डिटेक्ट होती है। अब सॉरी, प्रेगनेंसी नहीं डिटेक्ट होती, ये डिवोर्स होने के 7 महीने बाद ये एक चाइल्ड को डिलीवर करती है। तो अब देखिए, मतलब डिवोर्स होने के 7 महीने बाद अगर कोई चाइल्ड डिलीवर्ड होता है तो ये विद इन 281 डेज आएगा। तो इस चाइल्ड के जो फादर होंगे वो कौन होंगे? ये वाइफ की जो डाइवोर्स हस्बैंड है वही होंगे। तो अगर किसी और की एक्सेस डिस्प्रूव किया जाता है तो समझ